the first deal that we're going to discuss is about Linklaters advising bulk special administration. In the normal course of dealing, where Ludo is still here, we would be sharing the screen right now of the articles that we've written, but currently we aren't able to do that because he's not here. So I will first introduce what's going on, what happened, then give you guys a bit of background, a bit of context, and then discuss the role of a lawyer into a deal like this. So we're talking about the special administration that Bulb have entered into. Bulb is a energy company with 1.7 million customers, and has recently became the latest and the biggest victim of our energy crisis recently, where it's needing help by one of the Magic Circle firms, Linklaters, to go through the special administration process. Welcome back.
So sorry, everyone. Obviously, on the first one we do, it wouldn't be a stream without some technical difficulties. So I'm so sorry I got kicked out, but yeah, I'm back. Thank you, Annie.
Yes, I've taken on. If you could just share the screen about the articles. Sure. I've spoken about the giveaway, and I'm just kind of giving a bit of context of what happened. But it would be great if you guys can see. Yeah, so this is our website, and this is the deal that I was talking about. Basically about Bulb administration. So now going into the context of this deal is that this is not a standalone case. In fact, Bulb is the 23rd energy company that has gone down. Others, including my previous energy supplier, Avo, rest in peace, is now taken over by Octopus Energy, which I quite like. So we've been seeing a lot of small energy companies going bust, and this is the context. So you ask why this is happening. There are a combination of factors such as the surge of price in wholesale gas, and in the UK, this is critical to electricity prices because we are actually still relying on gas from power station to generate some of our electricity. Energy companies also have to deal with the concept of an energy cap, which is how much these companies can charge, and the purpose of an energy cap is to ensure that consumers can get a fair price. But obviously, wholesale price of gas has gone beyond that, where supply is lower than demand, as you've seen probably physically, where cars are queuing outside a petrol station. That is just one of the many examples. But what we're trying to do with these series of live stream is not only on the commercial awareness on what's going on around the world, we've covered that in the first part of this live stream, but also kind of understanding the commercial law behind each deal. And now I invite Ludo to talk about the areas of law that this deal are involved and what do the lawyers do when they are kind of like typical tasks and so on.
Thank you, Annie. No, that was a brilliant summary of the energy, as you say, crisis that's, it's been ravaging the market. So it's definitely a major topic to discuss in an interview or an application. And like you said, we always try to go beyond just a story and to consider, okay, we are applying to a law firm. So what sort of aspects would the law firm be involved in advising, what departments? And that's specifically what we've been trying to do here. In this case, obviously, we will be focusing quite heavily on restructuring and insolvency as an area of law because it's an administration. The interesting thing actually here in this case is that usually when you have these big service providers that go and fail, they go into administration, what happens is that Ofgem, who's like the provider, they move them they follow this process called a supplier of last resort. And what happens in that case is that all their clients are sort of moved to another surviving supplier, let's say, so that they can continue to be provided with the energy that they need, to sustain their house and, not be really cold at home, basically. In this case, due to Bulb's size, it qualified for something called a special administration regime, which means it will run as expected. It will continue to run so that consumers will be able to keep having their energy as they paid for, but they will have an administrator in charge of the whole thing. Now, obviously, when an administrator comes in, they'll be looking to offset some cost in order to pay back creditors and all the liabilities of the company. So what's happened here is that the government has stepped in and tried to provide some, as you can see in our article here, they've set aside £1.7 billion for the administrator to cover these costs. And that's a very important aspect because it provides that this process that they're following, so the special administration, is quite an expensive one, which, as we said here, you have this additional cost from the government, which will obviously have to pay it back. And it's quite an interesting one because it's not the standard thing. So what's really interesting that you can pull on in an interview is first start by mentioning how we said the usual process of a supplier of last resort, but then follow on and say, well, we have Bulb that in this case is such a major supplier with such many customers that it prompted the government to step in and adopt this other resource or procedure, as we said here, so a special administration to ensure that their continuity in providing the services in protecting consumers in such challenging times. And I think that's a very interesting aspect to consider. And restructuring and insolvency is a very interesting area, especially with this whole aspect of an energy crisis, with a lot of companies going down or suffering financially. Lawyers in this area have kept very busy, and they'll have to think on their feet and be able to apply to these new procedures. So I think it's a very interesting point. I don't know, Annie, if you had any points on that, but that's sort of my take on the legal aspect of the story, let's say.
Obviously, I think apart from restructuring and insolvency, another part is kind of procedure-wise. The dispute resolution department will also be drafted in. A lot of the time when you're working in a law firm, there are a lot of cross-practice, even especially with a deal that big. You're dealing with a company of 1.7 million consumers that you're putting through a special administration. So in the dispute resolution department, a lawyer would be, first showing an understanding of the court procedure, putting forward an argument that persuade the court and potentially the Secretary of State for granting a direction to enter into an administration funding agreement. A direction, in other words, is a technical legal term, but it just means kind of an order to do something. I would also say, if you are interested into understanding a bit more about this deal or just general background of what happened to Bulb, I would definitely recommend the podcast of Wake Up to Money by BBC Sounds on the 23rd of November 2021, titled The Lights Go Out at Bulb. It's conversations with consumers, expertise, explanation of what special administration is, causes of administration, and a general overview of the UK energy market. And for those who loves a podcast, then I definitely highly recommend. Another aspect of, you are reading our articles that we publish on the Legal Update. As you can probably tell from subheadings, interview essentials, how to apply this in your interview for applications. You can, a leading question can be, how does this deal capture your interest / imagination working at Linklaters? And just on the top of my head, there are 3 things that you can probably say. For example, working on headline deals, Bulb being the largest UK energy supply business to collapse recently. Secondly, you're working on first of its kind legal agreements, so exposure to legal precedents and challenges. And thirdly, closely how the work is closely corresponding to current affairs. Also, I think finally is kind of want to share the research trial of how we get to the kind of information, just sharing how you can also get involved with, if you want to go away and read more about this. A law firm website would be a good start if you want to look at it through a commercial law perspective. If you want more kind of market and economic analysis, Financial Times is a good idea. Obviously, subscription's not, you need to be a subscriber of the Financial Times, but email your law school if your law school hasn't got a subscription. Definitely utilize your university resources. And finally, obviously, podcasts. There are a lot out there that will have covered the story as well. yeah, that's all for me.
That's excellent. Thank you, Annie. That's really helpful, and I'm sure a lot of our viewers will find that really helpful, the way you ran through that. So, yeah, if you have any questions about this sort of story, pop them in the comments. We'll try to address them as we go, as we said. Um, just for the purpose of time, not to spend too much on one single story, I think we'll move along to the Greg story, which, as we said, we will cover one deal, one case, and one trend in the stream, which is sort of the format we'll try and follow. So the case we followed is something that you may have seen on our Instagram page, because we shared it yesterday, or was it today? We shared it publicly just so everyone could sort of have a look at it and then come on the stream with sort of an idea of what's going on. We think it's a very interesting case. As always, litigation provides for some very interesting arguments in the courts and very relevant topics. In this case, we're talking about a major, party like Regs taking on Zurich Insurance. And the case matter here, so the main crucial part of this whole case is just the insurance provisions to cover the losses that Greg's incurred during the COVID lockdowns, basically, because they had to close quite a lot of the stores. As you can see, it suffered losses in over 2,200 of its stores. So it's a very big range. And what's the key aspect here, as you can see in our article, what we do is cover sort of what's going on to give you a brief idea of the case. And as you can see, Greg's believes that it's owed between 50 million and 100 million in payouts for these losses, which it incurred in respect of 2,000 of his stores. On the other hand, we have Zurich Insurance, who instead thinks they should only pay 2.5 million to Greg's due to the business interruption policy, and that's sort of the cap that they want to apply. So as you can see, quite diverging sort of expectations as to how much to pay out. The difference can be justified and explained basically by the fact that Greg's thinks that each single store closure counts as a sort of single case that should be covered by the insurance, whereas instead Zurich only thinks that they should all be grouped into one, and that's why it should only be capped up to 2.5 million. And insurance policies in general have been a very topical aspect of sort of businesses during lockdown. You can probably remember the big case the FCA brought, where the Supreme Court actually ruled on this in terms of the insurance, whether insurance policies are covering COVID-related losses. And that's especially a very relevant case in this Greg's case, because it's something that Greg's is trying to point towards and saying, look, you said that COVID is covered under such insurance policies, so surely we should be able to apply the same metric to this case and recoup the losses we believe are between 50 and 100 million. So it's definitely a very interesting topic, and I think something that potentially can be definitely brought into an interview quite easily, especially if you're interested in litigation. This can be a case that's, ongoing, so very interesting. We can see further developments, also because it can establish an important precedent. We expect it obviously to rely on what's been decided in the Supreme Court, in the sense that COVID policies such as these should protect businesses, but there's always potential surprises. You never know in the courts, so it's something definitely to keep an eye on. So yeah, very topical, and that's sort of a brief summary, whistle-stop tour of what's happening. Annie, I don't know if you had any little points you wanted to add before we sort of look into it a bit further.
I guess my point would probably like contribution to if you are also interested in insurance. I think one of the good sources is Legal 500, where you can then look at the top firm that are performing really well and have got band 1 ranking in this area, including, the classic Clyde and Co, Kennedy's, DAC Beechcraft, HFW, RPC. But I also saw a really interesting comment from our comment session. How is the FCA test case related to the Greg's case? And I think that is quite a good one to be addressed. Ludo, if you want to take that on.
Yeah, definitely. I was going to point it out. Thank you so much, Joanna, for commenting that. That's a really good question. Something that we're actually going to address. But as you can see, it's something that we deal in this sort of paragraph or of our article. So what we're saying is that, just to summarize, so the Financial Conduct Authority had brought this claim against insurance on behalf of over 300,000 policyholders back in 2020. And the crucial aspect of that was to clarify whether COVID-19 losses should be covered under what's called as the standard business interruption policies provided by insurers. And in that case, the High Court, as you can see from here, ruled largely in favor of policyholders. And this was a decision that was then upheld by the Supreme Court in an appeal. So when we then look at this case and applying it to this case, we want to say, in that case, the Supreme Court backed the businesses and supported them in being protected by the policies they took out as insurance. So Greg's will try and make the argument that in this case, there's a very high degree of similarity in the sense that they have a policy which they believe is very similar because it addresses the same sort of issues in the sense of standard business interruption. And so if we go off what the Supreme Court said and the High Court said, we should have a case where, yes, we should have a higher payout. And the issue, as I think, in that sense, that's why, sorry, before I move on, so that's why you sort of link the two cases. Another question which I wanted to address, actually, Annie, which is sort of related to this, is from Edward. That's also a really good question because it's sort of linked to why we can relate the two cases. But as I said, the main aspect that will be deciding in this case will be whether the court thinks that all these store closures, so the 2,000 plus store closures, are different events or they're just one single event that occurred during lockdown and which should have a cap in terms of its payout of 2.5 million, like Zurich says. Otherwise, if it's all little separate events, then we can look at a much bigger payout, like Greg's is saying, of 50 to 100 million pounds. So that's sort of the aspect that will be crucial in proving and deciding the case ultimately. Don't know if you had any other thoughts, Annie, on that though.
No, I think it's really good, but it's interesting to see because I think, again, people would say it's the detail of the policy that we should look if we were able to look at. It's how there have been long debates about the business interruption clause in an insurance policy, and a lot of the companies that have struggled, especially high street. I mean, just if you have a quick walk down London, a lot of like Itsu and Pratt has closed down. And again, I think, as Ludo has mentioned, it will be very precedented once the judgments come out. Another thing is we've recently published a free article about the latest development. I don't know if Ludo would be able to show.
Oh, yes, sure.
Yeah, so you can continue to keep up to date with what's going on, and hopefully in the future and in our other stream where we continue to talk about different issues. And what's good is later on you'd start being able to link up how different stories are kind of indirectly affecting each other. And I think that was definitely my light bulb moment when I call myself I'm commercially aware. So yeah.
Yeah, definitely an interesting one. Just one last point that I probably wanted to mention is something that we've highlighted here in the for clients section on this article. Just in terms of when you address this in an interview, potentially something that's always interesting, in my opinion, is to sort of think, if you're the lawyer advising for each side, what sort of things you'd be considering. Because as you can imagine, being a law firm advising the insurance company has very different sort of arguments and thoughts as someone advising a policyholder. So just try and balance that in terms of your strategical thinking on the case. So pick out like points saying, for example, if you're acting for Greg's, you might want to think about the Supreme Court ruling and how that backs your case. But if you're Zurich, you want to establish that, not look, it's just one single event. We can't pay out 50, 100 million. So that's something interesting to consider, just to show your legal awareness, legal commercial awareness, and thinking as a lawyer in practice. And then something else, a little point, is just that in terms of the payments, something that we said is that consider how the FCA said that since the Supreme Court ruling, 1 in 3 businesses is still waiting for any form of payment. And that's quite, that surprised me when we wrote that, because I thought once we had the Supreme Court ruling, surely payments would start rolling in. But apparently that's still a little issue, and it's something that the FCA is quite conscious of and is following up on insurance with. It makes sense from one point, because it's quite a lot of payments to do all at once, and probably insurers will be trying to avoid it having to do it all at once and trying to sort of stretch it out as much as possible. But that's an interesting point to consider. And lastly, just if you're interested in Clyde and Co, they're acting on this one, so good story to bring in if you're applying there, I guess. Okay. Should we move to the next story, Annie? What do you think?
Yes. Unless there are any more questions from the audience, I think.
Good.
It seems all right. Let's move on to the next one.
So I'll just find the article, because the next story we'll cover is this one. Okay. Yeah, perfect. Annie, did you want to sort of introduce this? How did you?
Oh, I think
Yeah,
we can go ahead. I think just maybe before we start looking,
Sure.
before we look before we look into this article, I think there are some background knowledge that people should be aware of. I think there is a really good article from the lawcareers.net about what are the types of law firm partnerships, and so reading that would give you a good ground of knowledge on different types of partnership structure that we're about to mention in this article. But that is obviously background knowledge, and we're happy to share that link later. Oh, yeah, there we go.
Sorry, just assisting right on the go.
Yeah,
this
there
one
we
here,
go.
I think.
That is the one. I've definitely read that one. It even gives you the pros and cons and example law firms that are using the structure. Why we're looking at this trend is also kind of relating to the idea of retention rates when you're applying to a law firm, the likelihood of you being retained, and also as a trainee, you might be looking at the partnership track, and also the trainee partners conversion rate. So, for example, at Slaughter and May, most of the partner are trained at Slaughter and May as well. Whereas some other firms, for example, US firm, are really keen on the lateral hire, hiring people who are obviously maybe trained in the city or Magic Circle firm, but have a really good reputation in that area. Another insider kind of knowledge that I've gained recently is that when it comes to lateral hire, US firm has a priority to look for people laterally hired from people from the US firm first, then look at the Magic Circle people or lawyers. But on the flip side, Magic Circle tend to look for people who are maybe English firm based, then US firm. So that is, I think, why we're bringing up this trend is kind of also looking for the long term. When you're applying to firms, are you looking at the retention rate and the trainee to partner conversion percentage within the firm as well? But yeah, please go ahead with the article.
Yeah, no, that's a very useful one, and it's something that, as I said, when I was applying back for training contract and vacation schemes, it's something that's quite hard to get into, and I never really had an idea, to be quite honest, about the different types of models, what is specifically how they work. But it is a very important thing to start learning about and just have a general idea of, because it does play a part in law firm strategy, what they do, how they expand. It's increasingly becoming very important, and we'll see it now why that's the case. But a lot of top firms are modifying their systems to involve their strategy and to match the current times and ensure that they stay at the top, basically. So thank you, Annie. That was really helpful, actually, and feeds in really well with what we're going to talk about now, which is a story we've been covering basically for the past week or so. We've had an update today about it, actually, and it's just about the Lockstep system and how it could be coming to an end, as a lot of firms seem to be moving away from it or modifying it. And the crucial part here is that we're seeing this trend because a lot of firms are experiencing some challenges, let's say, in retaining and attracting top lawyers, especially with partners. They seem to be sort of attracted to top US firms who have a lot of money to spend on salaries, on bonuses to attract them and to keep them there. And quite frankly, when a partner has offered, a lot more money in another place, in another firm, they will undoubtedly be attracted by it if they don't think they're potentially valued in the same way, or they can get more of it from a US firm. So that's definitely a trend we're seeing. And it's something very interesting to consider if you're going in an interview with, I think, any type of firm, especially the big UK firms are potentially the ones that are a bit more at risk, let's say, against their US rivals. But something that undoubtedly will affect the legal industry as a whole, in my opinion. What we covered in this first article, which was actually published last week, is just how in the US there's been increasingly this trend towards away from lockstep models, which is this sort of remuneration structure in which partners are paid solely on their rank and seniority. So the higher you are, the more money you get, basically. And they'll instead, firms like this are incorporating more performance-based elements. And that's to ensure that if a partner is doing exceedingly well, they will get that extra amount of money that makes them think, oh, you know what, that's actually, I feel quite appreciated being here and I'm getting quite more money, so why not stay? They don't feel as attracted to leave. And that's a crucial aspect, because what's happening now in the general legal industry is we're experiencing a very strong pay war. And that goes all the way from juniors, so from trainee solicitor level, all the way up to partners. So as you can see, a lot of firms this year have been increasing the amounts they give to NQs. Like all the Magic Circle firms, I think, have increased it quite a bit, substantially, just to match each other's levels and ensure that they get the top talent. And that's gone all the way up to associates and to partners by increasing the payouts and remuneration models that we're seeing here. And something that you can back to say, okay, but why are US firms doing so well? How are they able to pay so much more money, let's say? It's the boost that they're getting from private equity. A lot of US firms are sort of dominating the market, and it's something that you may have seen on our Instagram post today. We've covered sort of a list of the top private equity advisory firms, let's say. And a lot of US firms are at the top of the list. And that gives them a strong boost in terms of fees charged and profits, which they can then spend on salaries, on attracting talent from partners all the way to juniors. So that's a very interesting point, I think. Something that I'll cover also later on. Annie, I don't know if you wanted to jump in. I just need to get on another article, but if you had any thoughts on that, well, just while I get that on.
No, all good. I think, yeah. I've also seen Joanna asking a question.
Oh, yeah.
Have candidates been asked at interview about their views on the pay war? What's the most appropriate way to respond if asked this question? That is a good one.
That is a good one.
I don't think it will come up unless it's some partner who's not had a good day and just want to throw you a curveball question, because you've got those precious interview time. But I guess views on pay war is, I guess, how this could come in an interview is about challenges facing the legal industry. Retention of talent has always been one of the challenges that the legal industry has been facing, and it's just now coming more and more apparent. Another kind of challenges that the legal sector is facing is the emerging of US players. A lot of the US firm has entered into the English legal market, where they obviously have the upper hand of the link with, the most lucrative and active legal market in the US. They have that advantage. And so I guess, the pay war or kind of remuneration in that sense would come in as a way of what kind of challenges are the legal sector facing? And the most appropriate response, if asked this question, I guess, would just be commenting on maybe the concept of retention of talent. If people are working, I think you also have to acknowledge the reality is that, the lawyers work long hours, and it's just, if you've seen a lot of legal cheek articles in the comments, which is, where the gold dust are, they are, I don't know. I guess I've kind of covered the point, about retention of talent and just US players coming in. But also maybe think about the point of inflation, because by the time when you qualify, the inflation rate would have been higher.
That's true. That's a good point. Definitely something to consider. But yeah, no, it's a tricky question, and as Edward says, it's well, it would be savage. That's quite very common to make. Yes, we all agree with that. So that's always a good, yeah. Just if you get a tricky question like that, just try it, like Annie said, to sort of address it in that sort of way. But yeah, I think it's quite rare for it to happen, like to be asked quite directly like that. The way you could bring it up is in the as part of the strategy of the firm, I think, because something that we'll be covering soon is how Allen and Overy has they were part of the sort of firms that have changed the Lockstep system. And for them, it's really paying out in expanding in the US because they're able to attract the top partners that have the top clients. And once you have the top clients, you have the sort of top money. Let's say you have the most money, and you can then go on and pick out the best associates, the best juniors. It all, it's all correlated. So if you can attract the top partners and retain the talent that you have, well, you're set. But it's trickier done than it is just by saying it like that. And that's especially true when also looking at juniors, and a trend in the sort of changes that we're seeing Magic Circle firms do when we speak about lockstep systems is trying to encourage their younger staff and the younger lawyers to stick with the firm and all the way to partners, especially if they think they have potential to be really great lawyers. And to do that, they're sort of shortening or accelerating the mechanism by which they can become partners and compensated for exceptional contributions, as Linklaters has done today. This is a story that we've covered today, actually. As you can see, there's 3 key changes that they've done, and it's sort of paying the top performing partners more, accelerating their system, and just having more flexibility to elect lawyers to the partnership earlier. So as you can see, it's ensuring that once they have the top talent at junior and younger level, they're happy to stay with the firm, and are not attracted as much by other US firms that just come offering a lot more money potentially, but instead see the potential to become a partner relatively soon. Obviously not too soon, but not, it's something that's an objective insight for them, and it makes sense for them to stick with the firm. Hopefully they enjoy it there. But yeah, I think that's the strategy from my point of view, Annie. It's just ensuring that you can hold on to that talent, and the talent actually feels happy staying with the firm.
Yeah, I think that's true. Another thing is the reality. I mean, if you read any legal business magazine articles, it always starts with revolving doors. The legal profession is a revolving doors. People move around a lot, and I guess what a firm could do is the remuneration, and again pairing with the reality of working long hours. You have, like, US firms are known to kind of have a completely different style of training. Some people like that type of style where you are thrown into the deep end and kind of small intake, whereas traditional English Magic Circle firms are large intake and structured training. And so the kind of discussing the lockstep system or the end of it, it's kind of a way into understanding, and also maybe discussing your preference of where do you see yourself. The question of where do you see yourself in 5 to 10 years might come up in an interview, less savage, but you can bring that in, and drawing onto you've got the ambition of being partner one day maybe, and drawing on how in reality this is how the firm could support you in that. Just transparency and all that.
Yeah, definitely. And potentially, as a last point, I've just opened this other article we had on the paywall, is just because if you are discussing the story, you're looking, of course, money is a big part of attracting lawyers and making sure they're happy staying at the firm. But and a trend we've been seeing is sort of firms looking at beyond money, what they can do to attract and retain talent. And for example, there's been like having switch on and off options, having more control on their billable hours, the work they take on, more paid parental leave has been quite a big one. And I think it's all these alternative ways to make lawyers feel happy being at the place where they work. And sometimes money is great, but it's potentially not enough for people, and especially with working parents, something like more paid parental leave can make a really big difference, and it makes you feel like, yeah, this is a really great place to work with, and I'm happy to stick here, even if I could earn 10K more somewhere else. So that's always something else to consider, I think, having different strategies and showing to the firm you're applying to that you're considering the business aspects of retaining talent and how important it is to hold on to these key lawyers to boost your profits and attract and keep the top clients really for your firm. So that's something interesting to consider, I think.
Yeah. I think also another point is I'll bring in the idea of a lawyer's personal brand. Some of the clients pick legal representations not because of the law firm branding, sometimes it may be, but mainly is how well it gets along, the company and the client gets along with their lawyer's representative. You might have heard of the term of relationship partner. So these are partners in the firm where they have where they focus on working and understanding the clients, keeping up to date with them, and their role is pretty much, apart from what you might have been doing in your associate/senior associate stage as a partner, you also take on additional responsibility in keeping in touch with clients. And so, retaining talent in that sense is really important, because when they leave, they probably bring the clients with them. And so firm would be like, kind of thinking about the cost effective or the scale of economies, it might be worth kind of start investing into junior lawyers and working, kind of reviewing this like structures so that this won't happen in the future. So the idea of a lawyer's personal brand, how well they present, and again, clients are picking lawyers because they get on well with them and because of the skills and the craft that they can bring to the client, sometimes rather than picking which firm they're at. And sometimes maybe it doesn't even matter like which firm they're at. And so as an organization, thinking law firm as a business, this is one of the way of kind of handling that challenge.
Yeah, definitely. Something very important. Like working now as I'm having my training contract. I'm in my third seat, just for anyone that's didn't know, but it's something that's very relevant, and building that sort of, like Annie says, that personal brand and establishing connections with clients is crucial. It's what the business is about, because it's a client-facing business, and you need to have that sort of aspect and be ready to, help with that. So very important point there, Annie. Thank you for sharing that. I've just put this sort of, if we have any last questions, please do put them in the comments about any of the stories, about anything you'd want. We're sort of happy to answer them, just because we're on 40 minutes, so it's going to the end of the session now. But yes, if you have any last minute questions, just put them in the comments. Otherwise, Annie, is there anything you had some last minute thoughts to share with us? No, I think that's, well, okay. As I said, thank you for everyone that commented on the giveaway. We're going to try and do this. Annie, what did you promise people? Just so I know not to disappoint.
It's just, there's a giveaway of your hoodie.
I think we're giving out a hoodie.
Not the one that you're wearing, of course.
No, just for anyone. We've got the little litigation digest hoodie, but we've got other ones. You can pick your choice. We can even make your personalized one, and then we'll send it straight to your door. Wow. So absolutely fantastic. So let's see if this works. So everyone that's commented has been on here. So let's see who's gonna win it. Oh, I should have put my own name.
So you can win it. That's amazing.
Oh, Edward. Oh, of course. I mean, yes, I'm not even I think you even won the best comment of the day. Where is it? Yeah, there it is. That's double winner for that too. So Edward, I will contact you, and we'll get you sent a nice little hoodie. And amazing. Okay. Thank you so much.
Joining us, guys.
Well, it was an absolute pleasure to have you and to speak with you, Annie, this evening about commercial awareness stories. Thank you for everyone for tuning in.
Subscribe to our channel, subscribe to our website as well for more stories, and we're hoping to do more of these in the future. So stay tuned, follow us on Instagram, Legal Update, and we'll let you know when's the next time.
Yeah, let us know your thoughts too by DM wherever you want. If you enjoyed this and you think it's worth us doing again, we'd really love to hear from you. So yeah, do let us know.
Feel free to
Otherwise,
message us. Any feedback we love to hear.
Yeah, definitely. Amazing. Okay, perfect. Have a lovely evening, and we'll catch up soon. Thank you, Annie.